Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome to the deep dive. We've got this really interesting legal challenge today, straight from the intellectual property world. Our mission is to cut through some pretty dense technical stuff, but not to talk about the tech itself. We want to uncover this core tension, really, between getting things done quickly and being fair in the legal system.
That's right.
We're looking at a Calcutta High Court judgment from their IP division. And like I said, this isn't about whether a specific gadget, I think it was a hydraulic disc brake, is actually new.
Yeah, that's subject matter.
Right. It's about, judicial oversight. When a body like the patent controller, who's sort of like a judge but not quite, when they reject a patent application, how much reasoning do they actually have to give?
Exactly. How detailed does that no need to be?
Yeah. So we're going to unpack why the High Court actually stepped in and overturned this rejection, basically because the justification just wasn't there.
And that procedural question, well, it's everything in this case. You have the controller's office, right? They handle, thousands of these complex applications. They need efficiency.
Of course.
But then you have the courts demanding reasoned, transparent orders. So this case involving Stromag gmbh, it really sets a pretty high bar for accountability in the Indian IP system.
Okay, let's dive in then. We need the basics first, the sort of where and when this all happened. Give us the case details.
Okay, sure. The case number is IPDPTA 12-2025.
Got it.
It was decided by the High Court at Calcutta, and specifically their original side, the Intellectual Property Right Division.
Okay.
The date of the judgment was the 4th of September, 2025. And the judge presiding was the Honorable Justice Ravi Krishan Kapoor.
Justice Kapoor. And the parties involved?
Right. So the appellant, the one bringing the appeal, was Stromag gmbh. They were the ones trying to get the patent.
Okay. Stromag.
And the respondents, the other side, were the Controller General of Patents, Designs, and Trademark in ANR, basically the official patent office body.
Got it. The applicant versus the government body. So Stromag gmbh, they were trying to patent this brake thing. What was the invention exactly, and how did this whole thing unfold over time? What's the timeline?
Well, the application goes way back, actually. Filed February 18th, 2013.
Wow, okay. That's over a decade.
Yeah. The application number was 179 KOL 2013, and the title was Hydraulically Actuatable Disc Brake and Azimuth Drive.
Sounds technical.
It is. So after filing, the Patent Office does its initial review and issues what's called the First Examination Report, or FR. That's kind of the first hurdle.
And what did the FR say, the initial objection?
They were pretty standard, but broad. Lack of inventive steps, which is Section 21J of the Act. That's always a big one.
Herculean hurdle, yeah.
Exactly. Also, lack of patentability under Section 3F and insufficient disclosure under Section 10. Basically not inventive, maybe not patentable subject matter.
Yeah.
And you didn't explain it well enough.
Okay, fairly typical objections at that stage, I guess. Stromag must have responded.
Oh, yes. They filed responses, amendments, the usual back and forth. But things got really critical around July 2022.
What happened then?
That's when the controller issued a hearing notice. And the objection had really narrowed down, focusing almost entirely on that inventive step issue.
Oh, okay.
And here's where the technical complexity sort of crashes into the legal problem. The controller argued the invention wasn't inventive because it was just an obvious combination of 7 different prior art documents.
7?
7.
Yeah.
Labeled D1 through D7. This process of combining existing documents is often called mosaicing.
Mosaicing. Right, like piecing together bits from older inventions to argue the new one isn't really new.
Precisely. So they had a final hearing in August 2022, and then on January 31st, 2023, the controller issued the final order, rejected.
Rejected based on combining D1 to D7?
Primarily on that ground, yes. Lack of inventive steps due to that combination. And that rejection order is what Stromag gmbh took to the High Court.
Right. And this is where, as you said, it gets really interesting because the fight shifts, doesn't it? It's not about does D1 plus D7 equal this break anymore.
Exactly.
It becomes about the rejection itself. So what was the actual legal question the High Court had to grapple with?
The core legal issue wasn't the technical merit of the break.
Yeah.
It was all about procedural fairness. The question was, did that rejection order, the one based on combining 7 prior arts, violate the principles of natural justice because it just lacked reasoning?
So not wrong reasoning, but basically no reasoning.
Or at least profoundly insufficient reasoning. Did the controller actually explain how combining D1 through D7 made the invention obvious? Did they do enough to justify saying no?
Okay, so what did Stromag, the appellant, actually argue was wrong with that final no? What was their main point?
Their argument was pretty direct. They said it was a major violation of natural justice. They pointed out something quite striking. The rejection order, it seems, spent pages and pages, over 24 pages apparently.
Why 24 pages?
Doing what? Summarizing the background, reproducing bits from those 7 prior art documents, D1 to D7, basically setting the stage.
Okay, laying out all the evidence.
Right. But then, after all that setup, the actual conclusion, the reasoning for the rejection, was basically, according to Stromag, delivered in a single sentence.
Wait, hold on. 24 pages of technical details from 7 different sources, and the final judgment is just one sentence saying, nope, not inventive.
That was Stromag's claim. That the order concluded, in essence, that the combination of D1 through D7 meant the invention lacked an inventive step. Therefore, application refused. Period.
That sounds incredibly brief, almost dismissive, given the complexity.
That was precisely their point. The fatal flaw, they argued, was the total absence of analysis. The order stated the conclusion, it's obvious because of D1 to D7, but didn't explain how or why.
No bridge between the evidence and the conclusion.
Exactly. No explanation of how a skilled person in the field would have actually combined those 7 specific documents to arrive at Stromag's invention. It was just an assertion, lacking the technical linkage.
Okay, but let's play devil's advocate. What if the combination was genuinely obvious? Does the controller really need to write an essay proving it? What did the patent office argue back?
Well, the controller's side tried to argue that the order, when read as a whole, did address the issues. They suggested that, the background provided, the summary of the prior art, the history of the prosecution, that all gave enough context for the final decision.
So they were saying the reasoning was sort of implied, even if the final sentence was short.
Kind of. They argued it dealt with the contentions raised earlier, like in the FER. Essentially, they defended the order as being substantively okay, even if that final crucial step, the explicit reasoning for combining D1, D7, was brief.
Okay, so you have this massive setup, 24 pages, ending in what the appellant calls a one-sentence rejection. How did Justice Kapoor at the High Court see it? What was the ruling?
The court's decision was very clear. The rejection order was ruled unsustainable, and it was set aside.
Completely thrown out.
Yes. And the matter was remanded, which means sent back to the Patent Office for a fresh decision. Importantly, it was sent back to a different hearing officer.
Oh, interesting. Not the same one.
Right. And they were given 4 months to decide it anew. But, and this is really crucial, the court explicitly stated it was not ruling on the merits of the patent application itself.
So they didn't say if the break should get a patent or not?
No. They made no finding on that.
Okay.
Their entire decision was based on the procedural failure, the lack of adequate reasoning in the rejection order. The order was legally void because of how it was decided, not what was decided about the invention itself.
Okay, this is where we really get into the deep dive part. The why. The court didn't just say not enough reasons. They used some pretty strong language, rooted in administrative law principles, didn't they?
Oh, absolutely. This judgment is a powerful lesson in the duty to reason that applies to quasi-judicial bodies like the Patent Office. The court didn't pull any punches and drew heavily on established Supreme Court precedents.
Like what?
Well, they brought up the famous Cronty Associates case, where the Supreme Court said an order from a quasi-judicial body must speak for itself.
Speak for itself.
Yes, and crucially, it must not be like the inscrutable face of a sphinx.
The Sphinx, I remember seeing that. That's such a vivid way to put it, a decision that just stares back at you, giving nothing away.
Exactly. It perfectly captures the idea of an unreasoned decision. And they didn't stop there. They referenced the Siemens-Eng case to reinforce that providing reasons isn't just good practice, it's fundamental. It's as basic as natural justice itself.
So failing to give reasons is like denying a fair hearing, in a way?
In essence, yes. And maybe the most powerful quote they used was from UPSC v. Bibu Prasad Sarangi, where the Supreme Court called reasons the soul of a judicial decision.
The soul, wow.
Without reasons, the decision is just an empty shell, right? The High Court basically said the controller failed this fundamental test. They summarized all that material, the 24 pages, but then offered just a bare conclusion without the soul, without the reasoning connecting it all.
It really sounds like the court was saying, look, we see you looked at the documents, but you haven't shown us how you used them to reach your conclusion. The intellectual steps were missing.
Precisely. They hammered on the lack of a rational connection.
Huh.
The court talked about the rejection failing the twin tests of why and what. You need both. They cited another case, Gurdial Singh Fiji, stating that reasons are the crucial links between the materials and the actual conclusions.
The links in the chain.
Right. And in this case, rejecting a complex application based on combining 7 different documents, you absolutely have to spell out that link. You have to show why that specific combination leads to obviousness. Without that why, the decision looks arbitrary.
Okay, let's connect this back to this specific patent issue, the mosaicing of those 7 prior arts. How did the court apply this general principle of duty to reason to that specific act of combining references?
The court was very direct about this. It stressed that mosaicing, combining D1 through D7 to attack inventive step, can't just be done arbitrarily by the controller. You can't just pick and choose bits without a clear rationale.
You need a reason for the mosaic itself.
Yes, and the invention still has to be judged as a whole. The court pointed to a key UK precedent, the generic UK limited case, which deals specifically with this problem.
What did that case say?
The High Court quoted a finding from generic UK that basically said it would be wholly subversive of patents and quite unfair to inventors if an examiner could just find piece A in one document and piece B in another and stick them together, unless
what?
unless the person skilled in that field, looking at the problem, would have been prompted or motivated by common general knowledge to actually combine those specific pieces.
Ah, so it's not just can these pieces theoretically be combined? It's would someone skilled in the art actually think to combine them to solve this problem?
Exactly. That's the crucial test. There has to be some suggestion or motivation in the prior art or common knowledge that would lead the skilled person down that path of combination.
And the controller's order didn't show that motivation.
According to the High Court, not at all. The controller just asserted that the combination of these 7 complex references made the invention obvious. There was no analysis, no logical pathway shown, and certainly no evidence presented of what technical prompt would lead a skilled person to combine D1 and D2 and D3 all the way to D7 in that specific way.
So by failing to show that connection, that why combine these, they failed the legal test for justification.
Precisely. The reasoning wasn't just brief. It was fundamentally incomplete according to established patent law principles on combining references.
Okay, makes sense. Now, just quickly, was this a unanimous decision by multiple judges, or was there any disagreement?
No, this was a decision by a single judge, Justice Kapoor. The judgment doesn't mention any dissenting or separate concurring opinions based on the material we look at. It was just his ruling.
All right, so stepping back, what's the bigger picture here? What does this decision mean for how the Patent Office operates day to day? What's the real legal significance for, people listening who deal with the IP system?
Well, I think this case sets a really clear and quite high standard for giving reasons at the Indian Patent Office, especially when it comes to complex rejections based on inventive step, and particularly when multiple references are being combined.
So no more one-sentence conclusions for complex cases?
Hopefully not. It concerns the judiciary is watching and will act as a check. You can't just issue a conclusory statement no matter how complex the underlying tech is. The rejection, especially when you're potentially taking away someone's valuable intellectual property right, must be backed up by detailed, clearly articulated technical analysis.
It sounds like it forces transparency.
Absolutely. It demonstrates the path the decision maker took. It ensures accountability and makes the whole IP system more transparent and hopefully fairer.
Okay, so if there's one single thing our listeners should take away from this whole deep dive, what would you say it is?
I think the most critical takeaway is this. Administrative transparency is simply non-negotiable for legal legitimacy. It doesn't matter if you're a patent controller or any other quasi-judicial body. You must show your work.
Show the logical link.
Yes. You have to articulate that rational connection between the evidence you considered in this case, the 7 prior art documents, and the final conclusion you reached, the rejection for lack of inventiveness. A decision that skips that step, that lacks reasons, is fundamentally arbitrary.
And legally void, even if, hypothetically, the underlying technical point might have been correct.
Exactly. The process failure invalidates the outcome.
That really drives home the point about process being paramount. And you mentioned the court specifically warned against cut, copy, and paste reasoning.
Yes, they did. They acknowledged the pressure for efficiency, but stressed that it can't come at the cost of substantive analysis and clear justification.
Which leads us to our final thought for you, the listener. Given this constant pressure, not just in patent offices, but everywhere, to speed things up, to increase output, how do we make sure that this kind of genuine, well-explained reasoning, the kind that speaks for itself, doesn't get lost? Especially in critical areas like intellectual property, where the decisions have huge economic impact. It's that classic tension, speed versus substance. How do we maintain the quality of the soul of the decision, as the court put it?
That's the million-dollar question, isn't it?
Something for y'all to think about. Thanks for joining us for this deep dive.